The number you have reached, 911, has been changed to a non-published number.
Hi folks, welcome back to Cltv. I'm your host Ken Lammers. We got another letter for you this week from John Smith again, who apparently has become a prolific writer. Hi Ken, I enjoy perusing your site each week. I am a prosecutor in Pitcairn County, and I'm getting ready to try my first big case before a jury. Seems like you do this a lot. Okay. Any advice for making sure I'm super prepared and ready to go? Any advice on creating a successful opening and closing statement? I will tell you, I am not loquacious. I'm pretty much straight to the point, lay it all out, bing, bang, boom type of speaker. So I foresee that opening and closing may not be too lengthy. Anyway, thanks for your time and any advice. John Smith. Well, John, there's a lot of things, of course, varies from jurisdiction to jurisdiction, who the defense attorney is, whether he's going to play by the rules or not, all that sort of thing comes into play. What your judge is like can be a huge factor, well, not can be, is a huge factor on how your jury trial is going to go. And all these things you're going to know better than I will. But I'm going to give you a few things to kind of consider. First of all, start out in your, start thinking ahead of time about possible motions in limine. And I tell you this because there are certain things, and a lot of this, again, may depend on what your defense attorney or your judge is like, but certain things that you have to do in motion in limine, your motion to introduce during the sentencing phase here in Virginia, the prior record of your defendant, your motions, and other motions that you may want to think about entering are things like, a motion having to do with forbidding or making the defense attorney pay attention to the law as to mentioning possible sentences during voir dire. For instance, not allowing the attorney to say what the mandatory minimum is or the maximum sentence is in voir dire. He's forbidden to do this. That's very clear under Virginia case law. However, a lot of attorneys want to do it. It's a nullification move, especially when there's a mandatory minimum sentence. They'll want to ask the jurors, can you possibly sentence this if you're required to do this after finding somebody guilty? Okay, that's not really information that the defense attorney will need to know. His rationale for it will be, well, we've got to know if he's found guilty whether or not the jury is capable of imposing the sentence that it's supposed to. Defense attorney doesn't really have any need to know that information. It's just a front for nullification. Now, on the other hand, it'd be nice if you knew it, but if you start talking about it, well, then you open the door, and all sorts of problems can happen. Another thing you may want to talk about, you may want to just specifically put it in front of the judge. Motion in limine to keep the defense attorney from arguing nullification. That way, hopefully, who knows if it'll actually work, but hopefully it'll keep him from going too far off the range when you get to the end and he ain't got nothing except to argue to the jury, should this be a felony, ladies and gentlemen? He's charged with a felony here for doing X, Y, and Z, and really, does anybody here think this should be a felony? That he should get felony prison time for this? That sort of thing. Clearly a nullification argument, and maybe we'll head that off and limine it. Again, you're going to know the defense attorney better than I will, and if you don't know the defense attorney fairly well, haven't seen him in a trial, ask somebody else who's tried a case with him and see what you may have to do ahead of time. Now, next, after you do your motions in limine, of course, voir dire. Don't forget voir dire. A lot of prosecutors don't put much into voir dire, and I'm not sure why not. There are certain things, the obvious things. Does anybody here have any prejudices against the police officer here who's involved? Does anybody here have any prejudice against this witness or that witness or anything like that? Those sorts of things, obvious things. You'll think of the pretty obvious questions. I think you should probably ask some sort of question about the type of charge. This is very important, in my opinion, in cases where the person is charged with having done something that in other circumstances would be legal. For instance, a DUI. You may ask the jury, okay, here, who here drinks? Yeah, I'll hold up my hand. Where I work at, I get maybe half the jury will admit that they drink. I think more of them do, but maybe half of them admit. And then the follow-up question is, okay, everybody realizes this isn't about us trying to keep people from being able to drink alcohol. This is about us trying to keep people from driving when they're intoxicated, when they could hurt someone. That sort of question. On other cases where you don't have a legal activity that has been made illegal through some reason, you probably still want to ask some sort of question about what your charge is, if for no other reason than to watch the jury see how they're going to react. During voir dire, try to ask at least 10 questions if you can. Sometimes that can be hard, but try to get somewhere in that range, unless you've got something really serious you need to ask about, and then just keep going, of course. If your jurisdiction's large enough, you may not run into the problem that I've seen in my current jurisdiction, where on a given day, 4 or 5 people on the jury pool may know somebody, and I've seen voir dires last quite a while because, well, I was coaching a football team when he was there, or he and my son were on a football team together, or that sort of thing. Other jurisdictions which are much larger, you probably won't run into that as much. You'll see in your jurisdiction. Now, if you've got a troublesome defense attorney, somebody who you know is just going to break the rules, you may want to ask the objection question. Okay, does anybody here, ask, and you're going to have to phrase this in your own way, but you understand that certain parts of the trial are meant to do certain things. For instance, in this part, we're asking you questions to see if anybody has any reason, conscious or unconscious, that they might have some sort of prejudices that would come to bear. And in the next part, where we do opening statements, we're supposed to tell you what kind of evidence you're going to see in the case. But we're not allowed to make arguments in this part of the case. We're not allowed to make arguments in opening statements. So, for instance, if I was to start making an argument, defense counsel would object. If he started making an argument, I'd object. So everybody understand that this is part of the trial, that objections are going to happen, and there's reasons for it. And everybody will go, yes, of course. And any other questions that you think might be necessary because of the way you may have to handle the case. Voir dire, like I say, you got to ask the questions to see how people react, and primarily it's about observing your jury. See what they're going to do. Get your feelings from them. Now, of course, and defense attorneys have to be aware of this too, but it's something that we have to be, I think, more aware than they do. Be careful about bats. If a protected class, primarily gender or race, which is going to include, well, everybody on your jury for gender, and, depending on your location, can be a significant amount as to race or ethnicity, however you want to state it. Remember, striking one juror, it gives the defense attorney a reason to claim bats. Okay? At which point you have to give, even though it's, peremptory strike, you have to give an explanation. And remember as well that if your explanation covers both that juror and a juror who's not in the protected class, or who's in the flip of it, say you strike a female juror because she's wearing brown shoes and the male juror sitting right next to her is wearing brown shoes. Supreme Court said, no, that's not acceptable. You know, basically, as far as it goes, depending on how your judge does it and how the Court of Appeals deals with it, it's an exception that swallows the rule, because almost everything is going to be, you know, this person is somehow going to mirror that person, depending on how wide you take it. But just be aware of it and try to not fall into that trap. Okay, so you get past voir dire, and you've watched the jurors when you're questioning them, you've watched them when the defense attorney's questioning them, you've watched them when the judge asks, you know, all the really broad, vague questions that he asked at the beginning, like, is everybody here over 18? You know, those kind of questions. So, you've gone through voir dire, your opening statement. Now, I'm of the opinion there are different types, well, not of the opinion, there are different types of opening statements. And there are different types of opening statements that defense attorneys can come up with. You know, for instance, the pinpoint opening statement, look, we're not going to argue X, Y, Z, we're going to argue A. You know, and the defense attorneys argue, that's something that the defense attorney can do. You can't so much, because in your opening you're not allowed to say, well, the defense attorney is going to do this, you know, because you're not, you know, he doesn't have to put a defense on. So you can't comment in your opening on what the defendant's going to do. Maybe some exceptions to this, for instance, if the defendant during voir dire has made claims X, Y, Z, well then, you know, you could argue that that's opened the door for you to make your argument, make your opening and include X, Y, Z in it. You know, that's cutting it close to the line, but it's there. So I think there are basically two types of openings that a prosecutor uses. There's the story opening. Now, the story opening is usually best for things where, you know, there's a pretty clear-cut chronology. You know, May 5th, 2007, you know, Pitcairn Bank. The doors open, and a man walks in carrying a shotgun. He orders everyone to the ground, and you go on and tell the story. Okay. Now, there's another type of opening that I think that prosecutors can use fairly effectively. It's the "we will show you" or "the Commonwealth will show you." That's more of an it is kind of they're crossovers. I mean, you can't do one without the other. I mean, even if you do the whole story, you're going at the end you're going to say, and you're going to see, ladies and gentlemen, that through this story you're going to see that he went to this bank, he had a shotgun, he held it in the face of the teller, he took $20,000, and that's robbery, ladies and gentlemen, and we believe you're going to find him guilty at the end of this trial. You know, so there's going to be something like that. Or you can just start out that way. Like I said, the Commonwealth's going to show you that Mr. Smith went into the Pitcairn bank, and we're going to show you that Mr. Smith pulled a shotgun out from underneath his jacket, and we're going to show you that Mr. Smith put that shotgun in the face of the teller. And you can do it that way. It's still kind of a story, and this kind of thing may work better. You know, Commonwealth's going to show you that Mr. Jones is a convicted felon. Commonwealth, convicted felon is not allowed to have a firearm. Commonwealth's going to show you that in Mr. Jones's bedroom, in his closet, in his house, Mr. Jones had a shotgun. Commonwealth's going to show you nobody else lived in the house. Commonwealth's going to show you that in his sock drawer, Mr. Jones had ammunition for the shotgun stored next to his socks. You know, that sort of thing may work a little bit better in that kind of case. You know, if it's an evidence-intensive case which doesn't lend itself to a storyline, you go that way, I think. So, you know, you get through your opening, and your opening, you know, you're at a disadvantage because, like I say, you're not allowed to say what the defense attorney is going to do. The defense attorney then gets up and says whatever he's going to say. He's, you know, a smart defense attorney who doesn't really want to see his client on the stand, is going to fudge some and talk about how your evidence isn't going to exactly come out clear. But you can't really control that. Then you go and put on all your evidence. You call your witnesses, chronological order in which you're able to get them to court. Unfortunately, you have to do this sometimes because that doctor can only be there from 9 to 10. He can't be there after 10 o'clock. He's got to be back to his patients. Well, okay, you can promise him you're going to call him at 9, despite the fact you really like to have him called at 3 in the afternoon after you've gone through 5 other witnesses. You're going to think about where you're going to call witnesses and that. Just remember, any witness you call after lunch, you can consider dead meat. You're not going to pay that much attention to them. So you want to call your good witnesses, if possible, early, as much as you can in the morning. In the afternoon, you call witnesses, but don't plan on, if you want them to have more of an impact, try to call them in the morning. Okay, let me say something here. Because witnesses and cross-examination and all that, that's all going to be spur of the moment somewhat, and dependent on each case. So I'm not going to really be able to comment on that too much. Let me just say one thing, though. Now, you've talked about being somewhat taciturn in the way that you react. And, you are a plain-spoken, quick-spoken person. Fine, that's wonderful. Works wonderful in bench trials. Doesn't work so wonderful in juries. If you're going to make an objection in the jury trial, let me say this. Don't just say, objection hearsay. The only time that I think you just want to make an objection and not state what it is objection, Your Honor, we covered this in motion in limine, something like that, to shut something off. And you may approach the bench and do whatever. But, if it's an objection for hearsay, objection, Your Honor, defense attorney knows, hasn't brought Dr. Smith, knows that we haven't subpoenaed Dr. Smith because we didn't know they were going to rely on something he said. I can't tell whether or not Mr. Smith is telling the truth or lying. I don't have the opportunity to put him in front of a jury to cross-examine so they can see whether or not he's telling the truth or lying, Judge. It's hearsay. Maybe a little bit shorter than that, but, explain yourself is what I'm saying. The explanation, the jury needs to hear the explanation. If it's at all possible, explain it to the jury. You're talking to the judge, of course, but, the explanation is for the jury. Don't just go objection hearsay. Objection best evidence. Objection relevance. Objection judge, whether or not the sky was gray on the day of the bank robbery is entirely irrelevant. Has nothing to do with what Mr. Jones did in the Pitcairn Bank. Explain it like that. Again, sometimes your judge won't let you do that. Sometimes the judge, you go, objection, sustained. You don't get the opportunity to explain it. But if you can, do it. Now, let's see. We've got through objections. Let's talk about closings. Now, closings in Virginia, and I don't know what it's like in other states so much, but in Virginia, because most of your trials take place, in less than a day, you start out from the beginning and you go to the end, you're just not going to be able to put together as coherent, unless you're really well organized and good at this. It's kind of hard to put together that coherent closing statement if the defense attorney has done anything. If it just kind of rolled along and you've steamrolled the defense, well, yeah, your closing statement's pretty much going to be, we've shown this, we've shown that, we've shown that. He's guilty. If the defense attorney's done anything, or had the ability to do anything, well then, he's going to throw some of that off. If the defense attorney's put on any evidence, alibi, witness, whatever, he's going to throw some of that off, and you're going to have to catch it on the fly. My suggestion to you would be, pick 2 or 3 themes or whatever, however you're going to handle it, and like write them in a couple sentences what you're going to do. By the way, don't write out your opening or closing. Write bullet points at most. Like write 2 or 3 bullet points, whatever, or the elements if you have to do that. I mean, you can usually use the jury instructions to do the elements if you have to, but write 2 or 3 bullet points, and then as the defense attorney is doing whatever he's doing with your witnesses, with his own witnesses, with his own client on the stand, mark them into where they fit in the theme, if they fit at all. Come up, do your closing, and let the defense attorney get up and do his. Don't be afraid to object if the defense attorney is doing something wrong in his closing. Defense attorney starts going off into nullification la-la land, object. Now, well, let me take that back. That's a call you're going to have to make. If the defense attorney's off in nullification land, you're going to have to choose whether you're going to object or not. And, kind of depends on the strength of your case and what you think your jurors are going to be like. You know your community better than I do. But if you think it's important enough, object in closings. I'm not a big believer in a tactical objection, and I know, for instance, a tactical objection that I've seen used, which drives me nuts. The prosecutor's tactical objection is, defense attorney stands up and goes, "They have to prove that my client's not guilty beyond any reasonable doubt." Objection, Your Honor, that's not the standard. The standard is a reasonable doubt. That's a distinction without a difference. However, it is how it's written, so they can stand up and object. It's not meant to do anything except distract the jury and, maybe throw the defense attorney off. Maybe you're angry enough at the defense attorney by the end to do that, but it's petty. But, like I say, there's a reason to object. And then you get your rebuttal. And rebuttal is probably your strongest point in the entire trial, because, let's be honest, up until rebuttal, you're playing defensive, mostly. You can't, in your opening statement, say that they're going to do any defense. What they're going to do is their defense. In your first part of your closing statement, you can do some, but you haven't even heard what he's going to argue yet. You've probably got a fair idea, but it's not fleshed out. It's all there when you get up to do your rebuttal. Every bit of it. And you can stand up and hammer away, and I think that's your strongest point. And it's where you should be hammering away. Hit them hard in the rebuttal. And like I say, use what the defense attorney said. Now, it is the part of the trial where you're most going to have to improvise. But by that time, your blood should be flowing pretty good and should do okay. Of course, if the defendant's found guilty, you get to do sentencing all over again. Mini trial for sentencing in Virginia, opening statements, introduction of evidence. A lot of times the only evidence that's really introduced is the defendant's prior record, and then closing statements, and the jury goes off to determine the sentence. A lot of times there's no real opening statements. If it's a pretty simple case and there's not any victim impact testimony and all that sort of thing, what you get is, well, Judge, we're going to introduce the record, and then we'll both argue closing. Again, you argue, defense attorney argues, and you get final argument. And then the jury goes out and does its bit. We'll say that trying a jury as a prosecutor, as opposed to doing it as a defense attorney, is different. And one of the big differences is, well, depending on what the defense attorney's like. If you got a defense attorney that believes that the rules apply to him, and he's going to obey the rules of evidence, he's going to follow trial procedure properly, well, then your case is going to be about the facts, and you're going to do pretty good. He's going to do as well as he can do, and within, the rules of evidence and within the trial procedure. Unfortunately, the lesson that a lot of defense attorneys learn, or seem to think is proper, is that in zealous advocacy, they should push and break the rules. Well, let me not say break. Well, depending on who it is. Some of them push, some of them break. They're going to do things, and it's not like they know. It's not like a civil case where they or their clients can get sanctioned for doing something stupid, and they're going to know that most of the time the judge is not going to throw them in jail on contempt for being zealous in advocacy in a jury trial, even if they're across the line. So sometimes a good portion of your job is going to be lawyer wrangling, and you have to be careful not to make it look like you're trying to obstruct things, that you're trying to keep the jury from knowing the truth. Like I say, a good part of that is, if you have to, do motions in limine ahead of time, and if you've got to do objections a lot, make sure you explain your objection. Objection, judge, this is voir dire. He's supposed to be asking the jurors questions to figure out whether or not they've got any kind of, conscious or unconscious biases which may affect the trial. This is not the place for him to be doing an opening statement and arguing his case. He knows that, judge, and those kind of objections, so the jury knows why you're objecting, what's going on. And jury trials, as we all know, are the big, they're what makes the adrenaline flow. Well, that pretty much wraps it up. And good luck in your trial. I'm sure you're going to do pretty well. Hopefully I've given you some useful information, and if I haven't given you anything that's really going to be useful, well then, you knew it all already, so you're good to go. And ladies and gentlemen, that's it for another Cltv. Next week, try to scare up another topic to talk to you all about. Have a good week.